So let's break this down surgically, okay? Section 33 lets governments temporarily override certain charter rights. For example, freedom of expression, association, even legal and equality rights. It does not apply to certain other rights such as mobility rights, democratic rights, or language rights. And the overrides have to be explicit. They have to expire either after 5 years or sooner if it's included in the legislation. Now, in theory, it's a safety valve for rare cases where the courts have misinterpreted rights and democratic mandate justifies a narrow correction. Again, narrow correction. But in practice, here's what the Alberta government is doing. For example, when teachers exercise their right to strike to negotiate better conditions, the government shut the strike down by force. They imposed a contract and invoked the Notwithstanding Clause to preempt any charter challenges. Who was protected here? It wasn't the students. It wasn't closing off lawful labor action. It didn't improve education. It wasn't the teachers that won. They just lost leverage, lost their association rights, and faced massive penalties for dissent. What the clause protected was the government's ability to legislate labor without meeting constitutional standards. Strike one. The protection was for state authority and political convenience, not of democratic rights or interpretation from the courts. Now, let's look at the transgender laws. Restrictions on youth health care, forced parental notification policies, and sports exclusions don't just regulate policy, they target a vulnerable minority who, specifically speaking, are also children. When legal and medical groups challenge the laws as violating, among other things, equality rights, autonomy, the government preemptively invoked Section 33 again. Who was protected? It wasn't the trans youth. Their rights are the ones that are being overridden. It wasn't parents. It strips families of autonomy by legislating identity. It wasn't the doctors that won. It restricts their professional discretion and shields policy from evidence-based judicial review. They don't want this to be reviewed by a court of law on an evidence-based review. The protection was for ideological legislation insulated by constitutional tests it likely would never survive. Strike two. And that's the pattern here. The Alberta government is using this not to respond to judicial overreach, but to prevent judicial review in the first place. That's not democratic accountability. It's an escape hatch from it. Look, Section 1 already allows governments to limit rights if they prove necessity, proportionality, and minimal impairment of those rights. If your policy can't survive that analysis, overriding the charter isn't principled. It's a concession that the law is constitutionally defective. And that's what we have here. The government is not defending democracy from the courts. Again, it's defending power from accountability. And that raises a deeper question. If a government can normalize overriding rights whenever litigation is inconvenient or charter challenges may be inconvenient, then where do we go from here? To what extent and where does this slippery slope end? Will it apply to political opponents? Look, rights matter most when they're unpopular. A charter that can be suspended whenever a government finds dissent inconvenient isn't a rights framework. It's a polite suggestion, and it defeats the spirit of the charter itself. The Notwithstanding Clause was meant to be exceptional, and the Alberta government, particularly the UCP government, is turning it into a routine political weapon for dog whistling. And the people being protected aren't students, it's not families or democratic institutions. The people being protected are the ones holding power. And that's where the problem lies.